With permission of everyone, I'd like to start this session. A very good afternoon to my seniors, colleagues, and everyone else present here today. Myself, Samrat Sengupta, partner Isla and Company, along with my senior colleague, Mr. Saurabh Ghosh, managing partner Isla and Company, shall be your host and moderator for today's session on legal framework in India, challenges and strategies in wake of pandemic. Before starting this session, I, on behalf of Isla and Company, would like to extend our gratitude and thanks to Lex Witness for granting this amazing platform during these trying times and bringing all of us together here today. We all know that the entire world is affected by the COVID-19 pandemic situation. There are people associated with medical profession and essential services who are combating the situation. I would like to thank each and every one of them for fighting this pandemic, being at the forefront of it. We all know that India is a fast-growing economy in every sector, supported by a very robust legal framework. But as you all know, due to WHO declaring COVID-19 a pandemic and the government of India invoking provisions of Disaster Management Act and Epidemic Act, a nationwide lockdown has been declared, and also there are partial lockdowns in different parts of the India even now. Very obvious, this has left a major impact on the legal framework throughout the nation. While the world is at stake now, today through this webinar, we will make an effort to look into the probable issues that might rise in operating the legal framework in a cohesive manner and different perspectives that may determine the contractual relationship between different parties. Now I would invite Mr. Ghosh to introduce our eminent panelists.
Thank you, Samrat. My greetings to all the panelists and the attendees for giving us a thoughtful insight on the recent crisis we are facing specifically in different legal sectors, industry, and the contracts. We have four very eminent speakers whose expertise is in their respective domain or phenomenon. Our first panelist for the day has an illustrious career in politics and law. He is our first panelist for the day. He is presently the governor of Meghalaya and a former governor of Tripura and Arunachal Pradesh. He had a distinguished academic career, having rank holdings in the school leaving examination and Jagdish Bose National Science Talent Search Scholar. He also headed the design branch of the Kolkata Metro at one point of time. He holds degree in engineering and law. His list of honors is long. He has been awarded Eminent Engineering Personality from the Institution of Engineers, Distinguished Alumni Award by the Institute of Engineers, Science and Technology, Shibpur, degree of Doctorate of Letters, honoris causa by Sri JJT University, Rajasthan, another doctorate by National Institute of Technology, Agartala. He is also considered very knowledgeable in the law relating to engineering contracts. I have been fortunate to work with him in few arbitration disputes. He has been also advising international parties of Bhutan, Bangladesh, and other countries. He has acted as joint and sole arbitrator in large number of disputes in arbitration. When he was appointed governor of Tripura by the president, he was already dealing with nearly more than 15 ongoing arbitration. I welcome His Excellency Mr. Tathagata Rai on the board, presently the governor of Meghalaya and former governor of Tripura and Arunachal Pradesh.
Welcome, sir.
Welcome. Samrat.
Our next speaker for the day is Honorable Justice Urjit Banerjee. Being born in a family of barristers, his natural choice was to be a bar of law. He did his bar at law from Lincoln. While in practice, he was well versed in the laws of company, commercial, property, arbitration, admiralty, shipping, constitutional matters. He has been elevated to the bench of High Court in Calcutta in the year 2013. Since then, he has passed many relevant judgments in many matters. Sir, please welcome, sir.
Thank you.
Our next speaker is our very own Mr. Jayanta Kumar Mitra, one of the senior advocates of Calcutta Bar. His contribution to legal fraternity is unparalleled. He is a barrister in law also. Being an institution in himself, he has known introduction. to be given. He was former Advocate General of State of West Bengal. I have been personally working with him in many matters for last 2 decades and learned a lot of different avenues of law and art of advocacy. Welcome, sir, on board.
Thank you.
Our last speaker of the day is Mr. Dushyant Dave, Senior Advocate, President, Supreme Court Bar Association. He has an illustrious, as we all know, he has illustrious career in legal field. His field of practice is extremely wide and involves various subjects like constitutional law, administrative law, civil laws, corporate law, substantial work in arbitration law, both domestic and international. He has appeared in many celebrated cases resulting in widely known decisions in the Supreme Court of India. Please welcome on board, sir. So,
Welcome, sir.
welcome.
Yes.
Yes, Mr. Ghosh, can we start this panel discussion now?
Yes. His Excellency, Mr. Tathagata Rai, I will invite you. I want to discuss the first question. If I may ask, in the wake of this COVID-19 pandemic, the comprehensive healthcare system we find is somewhere not up to the mark, and the state governments are struggling somewhere, as we find from the media reports. Health is a subject matter of the state list under the Indian Constitution. And it's enshrined as a fundamental right to, under the right to life, which the citizens should secure under the Constitution. Sir, how do you see a better infrastructure system can be developed by the state, and what the state government should look into? Any suggestions on this?
Thank you, Saurabh. Before I get on to the subject, I have a small request. Please drop the excellency bit. It belongs to another age. It's not necessary. Now, on the subject, the first thing that we need to understand about COVID is that this is like an alien landing on the earth, something about which we know nothing. Nobody knows nothing. Not here, not in India, not in the United States, not in China, not in Europe, nowhere. So we are all groping in the dark. And I am a little distressed at seeing occasionally that people say that this should have been done, why didn't the government do this, or why didn't that government do that? This kind of thing. Nobody knew anything. See, on 25th of March this year, when the first lockdown was introduced, it was imposed for a period of 3 weeks in the pious expectation that in 3 weeks the thing will be over, or 3 weeks, or give or take a few weeks. But it didn't happen that way. And we are now on to the 4th month of this pandemic. So what is to be done further can only be determined by a process of trial and error, no other method. Now, there are several possibilities. One is the vaccine. This vaccine is being worked upon, but according to the latest indications, this vaccine will be available only in the early next year, not before that. So vaccine is a long shot that way. Apart from vaccine, what can we do? We can occasionally do long shot with these lockdowns, but we have seen what terrible effects lockdown can have on our daily life, on our society, and on the economy of the country. So many people who are dependent on the functioning of the country are totally at a loss. They are economically in bad straits because of this lockdown. So occasionally we'll have to provide let-ups, we'll have to have gaps in the lockdown. But at the same time, what the Prime Minister emphasized during his last speech to the Indian audience, he had said that the lockdown is not a time when you relax, when you let down your guard. you actually have to double your guard. You have to be more careful. Now, apparently, that is not being adhered to by most of the country. Over TV, we get to see people going to markets and then standing there shoulder to shoulder, cheek by jowl, and then in the process, whatever happens, happens. Transport, talking about my hometown of Kolkata, transport is in shambles because what kind of transport will ply, what fare will be paid, how many people will be taken in every bus. I'm talking of public transport is all very fluid. So with all these things, the position is very uncertain. So all that we can do right now is maintain lockdowns from time to time, have gaps during lockdowns and between lockdowns, preserve, maintain, and observe all possible the precautions that have been enjoined, like wearing masks, like now keeping social distances, and such like. And meanwhile, pray to the Almighty. I can't think of anything else. As for its implication on the legal world, because I have never practiced in a court. We have three very eminent practitioners and ex-practitioners who should be able to throw light on that. So I'm not going to comment on that. This is the way I see it, what's going to happen during the next few months, this is the way I see it. Thank you very much.
Sir, as you said about the practice area, if I may ask, as a technological consultant with wide experience in the field, do you agree merely granting extension of time cannot be an adequate remedy for contractors having weak bargaining power and financial accommodation? Should they be allowed to set right the losses suffered owing to pandemic?
That is going to depend on the terms of the contract. Unfortunately, for the last 5 years, I have been out of touch with my subject, that is engineering contracts. So I'm a little handicapped, but still I'll try to do my best. We talk of force majeure, right? Now, force majeure by itself doesn't mean anything. What will constitute force majeure has to be laid down in the contract. And if it is not laid down, we'll have to imply conditions, which is very, once again, a very murky area of law. And it's based on that we will have to figure out the possibilities or the likelihood of the client compensating the contractor for losses incurred due to corona. You see, it is, far as I have understood, the loss rests where it falls. Some disaster befell all of us. It hit the client partly it hit the client and partly it hit the contractor. Now, whether the liability should be passed from one to the other will depend on the terms of the contract. And if the contract was drafted and agreed to before the onset of corona, then it's most likely that there won't be anything in that. And then, as I said, we will step into a very murky area of law. Subsequent to that, perhaps corona would have been written into the contract. But if it is not written into the contract, eventually the courts will have to take a call on it and lay down whether it is to be read as an implied condition in the force majeure conditions or otherwise. Other than that, it's very difficult to speculate anything.
Sir, as we were discussing the state's role and the center's role, do you think that the central government should have more powers under the constitution to bring in new law and create new laws in coming days to handle the pandemic situation through the state governments? Are our laws or the structure as it is under constitution, state being health being a state subject, somewhere not allowing the central government to be more stricter in handling the situation?
See, I personally think, and this has got nothing to do with COVID, I personally think that the center ought to have more powers. Now, the scheme in our constitution is, as far as I have understood, is that the residuary powers are with the center. Now, there are other constitutions, like, for instance, that of the United States, where the residuary powers are with the states. So in such cases, all that you've got to do, if our intention is to have the residuary powers with the center, we have only got to say that these are the powers, or this is the state list, these are the powers which are entrusted to the state, and the rest all belongs to the center. That would have made things very simple. But here we have a state reunion list, we have a state list, we have a concurrent list, things that makes things very complicated. Now, whether we should have more powers to the center, yes, I personally think we should have, because there have been certain centrifugal tendencies in India, and certain cases of what Ambedkar referred to as localism, which have warped the administration of justice in this country. Now, that would not have happened if powers were with the center, but they are not, and as a result of that, there are these distortions in the administration of justice in laying down the law. Quite a few things, particularly law and order, which is a state subject, which is zealously guarded by the state. I think the center ought to have a greater say in the matter of law and order. We already have certain features like NIA and ED, where the center can have a word in respect to law and order, but by and large, it's a state subject. States are very zealously guarding it. And I have perceived, both as a governor and earlier as one in politics, that this is giving rise to very undesirable distortions.
Yes, sir. I understand the confusion would have been less in this scenario what we are seeing if the state center would have more powers. Thank you so much for your insight. Shamrad, let's invite now Justice Banerjee to the board.
This is Banerjee.
Yes.
Sir, I will take this opportunity to ask you divert the conversation toward the virtual courts.
Yes.
So how do you see the effective uses of virtual courts in Indian judicial system to respond in effective and timely delivery of justice in the post-COVID-19 era? Because we are forced to enter into this virtual courts now in this COVID-19 era, post-COVID-19 era. Do you think going forward we can think of a system where both virtual courts as well as the physical courts can simultaneously operate? And that may we put our beneficial use to that?
Yes, Shamrat, I think this is an extremely pertinent question under the circumstances. The answer to your question very shortly would be in the affirmative, in the sense that virtual courts can definitely supplement real courts or physical courts, as it were. But in my opinion, virtual courts cannot be a substitute for physical courts for all times to come or for at any time. We are holding virtual courts now. We are constrained to, because learned lawyers, for valid reasons, are reluctant to come to court for the fear of being exposed to COVID. Now, my experience has not been so good enough. I'll tell you, the problems are, number one, poor connectivity, internet connectivity. In the High Court building, at least, I can tell you, in the Chief Justice's chamber, where I am the bench partner of the Chief Justice. So there, the connectivity has not been good. Secondly, 70% of the learned lawyers practicing in the Calcutta High Court, they hail from the districts, not from Calcutta city.
Yeah.
And accessibility to internet connection in the districts and suburbs are far from happy. That is what I understand and I read. Thirdly, most of the learned lawyers are not that tech savvy that they can operate a laptop and take advantage of online hearing. Personally speaking, I am not tech savvy at all. I am technologically challenged. And I have no hesitation in admitting that. When we hold virtual courts, there are people from the registry who are well versed in computers and all. They are assisting us all the time. But the learned lawyers are not getting that benefit. So that is another point. Fourthly, in case of a natural calamity, the electricity connection breaks down. As a result, the internet connectivity is gone. Take, for example, the recent cyclone that hit Calcutta. Well, there's some controversy as to how it is pronounced. Some say it's Amphan, some say it's Umfan. Whatever it may be, it was a disaster. There's no
But
doubt.
it was not a fun.
Now,
It was not at all a fun.
not at all a fun, right? That's right. Now, we all know how Calcutta was devastated completely. And personally speaking, I can tell you, I did not have internet connection for 10 days. I don't know, Mr. Mitro, Mr. Ghosh, Saurabh Ghosh, what you faced, but for 10 days, I did not have internet connection.
The same problem with me also.
Yes. Now, so therefore, such kind of calamities can hit any part of India. And during that period, there'll be no internet connectivity, no virtual court. And finally, again, this is my personal view, that in a physical court, in a real court, the degree of solemnity attached to the proceeding is much more than conducting a proceeding on a computer screen. For example, let's say hearing of a suit, a witness action is going on. It is very important for a judge to notice the demeanor of the witness in order to come to a conclusion about the credibility of the witness. Now, this would be very difficult on a computer screen. But as I said, I mean, these are some of the demerits that I think of the virtual court system, but definitely it can supplement, in the post-COVID era, it can supplement the physical court system, particularly for hearing of matters which would not take long or would not involve voluminous papers. For example, bail applications, anticipatory bail applications. And it is also important to have the virtual court or to conceptualize the virtual court system as a supplement, because that will lead to greater disposal also. Bail, anticipatory bail applications need to be heard out as expeditiously as possible because they involve personal liberty of citizens of India. And we all know that there are backlogs in all courts. So I think in the post-COVID era, the virtual court system can act as a beneficial and helpful supplement to the real court system.
Thank you, sir. Sir, taking this conversation further, as you said, the Calcutta suburb districts are facing problems. I'd like to draw your attention towards the district courts. The district courts and the subordinate courts today lacks appropriate infrastructure for setting up a virtual courts in itself. So is it time to effect the immediate overhauling of the total infrastructure for creating virtual courts in lower judiciary, which shall, as we think, which shall substantially reduce the cost of litigation? So we can just convert this crisis into an advantage by doing the overall, by developing the overall system.
Well,
What do you think on that?
I think the answer must be again in the affirmative. Yes, I think it is time that we all have to seriously consider about developing and improving the infrastructure regarding the internet, etc., to be able to hold virtual courts in the districts, district courts, and the subdivisional courts. The present infrastructure is not so encouraging. I have personally visited Birbhum. I am the zonal judge of Birbhum district. And I have had a detailed discussion with the learned district judge there. We are taking up projects. We are putting in requests to the state administration, because after all, the funds will have to come from the administration. And we are sending proposals. No doubt that time has come to take steps for improving the facilities in the districts, which will inure to the benefit of litigants, learned lawyers, and to everybody, and to the overall benefit of the judicial system, and help in the disposal, better disposal of cases, in more convenient disposal of cases. But as I said, for some time to come, we will face the technical problems which I pointed out when I was answering your first question. But yes, the answer to your second question is yes, the time has come.
Thank you, sir.
Comrade, may I put a legal question?
Please, sir.
Justice Banerjee,
Yes.
the English laws has a concept of partial frustration,
Yes.
and we also find similar concept of temporary impossibility in American jurisprudence.
Yes.
But under Section 56 Contract Act, we only find frustration in Indian Contract Act. Whether the present contractual disputes in pandemic time can be interpreted in view of the partial frustration or temporary impossibility?
Well, I don't see as a matter of principle why not, Mr. Ghosh. Although the concept of partial frustration or temporary suspension of contracts, that concept is not perhaps so popular even now in India, but we all know what the concept of frustration is. It's basically, it's a mode of discharge of a contract when the contract becomes impossible of performance for whatever reason. It is basically a Roman concept, and this is interesting. I remember this from my student days. One instance that was given in the textbook, that when a contract was made by somebody in Rome to deliver a slave to a landlord or whatever, and the slave died after making the contract. So it was held that the contract is frustrated because the subject matter of delivery is no more. And then it was developed by the English courts, Taylor and Caldwell, various cases. Even the Supreme Court has spoken eloquently, Mugni Ram's case in 1954, and subsequently several cases. Well, I'm sure this concept can be imported into our jurisprudence, but then just because a contract becomes difficult to perform, that may not lead the courts to hold that the contract is frustrated. The difficulty must be such that it must be totally impracticable and to perform it. You are perhaps aware in a recent Bombay High Court decision, which was delivered in April, it was an arbitration petition where the contract was regarding delivery of some steel products. I'm not very clear about the facts. And there was a bank guarantee involved. The purchaser invoked the bank guarantee because there was default on the part of the seller. And the seller went to court by way of an arbitration petition, Section 8, I presume, of the Arbitration Act, seeking injunction, sorry.
Section 9.
Section 9, sorry, correct. And Bombay High Court refused injunction. One of the grounds, of course, was that bank guarantee contract is an independent contract. It has nothing to do with the parent contract. But there were other reasons cited there, given there. One was that steel was an exempt product, and it was the steel industry was not under lockdown. It was really not difficult for the seller to perform the contract, had the seller really tried to. So diligence is one factor which has to be seen, whether the party at fault in default has exploited all avenues to be able to perform his obligation under the contract. I mean, these are several factors which have to be taken into account by an adjudicating authority, whether a court or an arbitral tribunal, before it is held that the contract stands discharged by operation of the doctrine of frustration. So in principle, I don't see why the concept of partial frustration or temporary suspension cannot be resorted to in Indian jurisprudence. But I would request Mr. Jayanto Mitra and Mr. Dushyant Dave to elucidate on that point further.
Yeah, we have questions for them also on this line.
Very
And
good.
so what you're saying is that the object has to be destroyed.
Correct.
Then only frustration in any form can be brought into.
Correct. The underlying object has to go. Difficulty, commercial difficulty.
Shamrat, do you have?
The commercial difficulty in performing is not enough.
Right, understood. Shamrat, do you have any more questions for him?
Yes, sir, I have one more question. In the wake of the COVID-19 pandemic, the government of India till now recognizes the workforce engaged in the government sector more of a secured workforce rather than the large contingent of people who are working in an organized sector in comparison to them. In view of the same, do you think that any economic or fiscal statute may be suggested for enhancing economic security or social benefit of the unorganized sector and the migrant laborers?
Well, that will certainly be very welcome, in my opinion. The unorganized sector, we all know, does not have the bargaining strength or the bargaining power that the organized sector has. And after all, we profess to be a welfare state. Therefore, I feel that the government should take all measures, including, if necessary, legislating statutes for welfare and benefit of these people who are not so fortunately placed as other people, if I may put it that way. I think we need to consider the chapter 4 of our constitution, the directive principles of state policy, more seriously. If you look at the articles there are several articles 37, 38, 39, 43, which talk about welfare of the people, which talk about a minimum standard of living, which talk about improvement of health, which talk about equality of opportunity of work, equal pay for equal work, etc., etc. I mean, it's a very good guideline, and as I say, it should be followed. It should be followed by the administration in taking a policy decision. I don't think the directive principles have gained the attention that it deserves till now. That is my personal feeling. And definitely some kind of measure on the part of the administration to help out the migrant laborers or the workers in the unorganized sector would be very welcome in a welfare state like ours.
Shamrat, I think we asked Mr. Tathagoda the same question if he has any view on this. Because, if there is a constitution, why it is not followed is something which is coming as a question to me.
The first point that strikes me is that what Justice Arijit Banerjee pointed out, that the directive principles have not received the attention from the judicial community that it deserves. I completely agree. Actually, when he was saying it, the first thing that sprung to my mind was Article 44. that the state shall strive to have a uniform civil code for all citizens is a thing which has been given a go by. And apart from that, would you mind repeating the question again? Actually, I lost a little bit of the thread.
Shamrat.
Shamrat.
Yes, sir. So, just wanted to take this further to Mr. Dave and this is very interesting.
No,
topic,
Shamrat. Shamrat, he has not finished. He wanted to know the question.
Just repeat the question, please.
So this question would be, so
The organized
the question here is that in
workforce
wake of the
question which you asked.
yes. In wake of the COVID-19 pandemic, the government of India till now has recognized the workforce engaged in the government sector has to be a more of a secured workforce rather than the large contingent of people who are working in the unorganized sector. In view of the same, sir, do you think any economic or fiscal statute may be suggested by enhancing economic security or social benefit of this unorganized workforce?
See, social benefit to the unorganized workforce can definitely be given. The question is, where will that liability fall? Will it fall on the party which is being made to pay that extra amount? Or will it transfer to the other party because they also are, they have a role to play in the contract? You see, this brings us to the question of bargaining power, which figured in Justice Arijit Banerjee's submission, that unequal bargaining power, does it invalidate or partially invalidate or modify the contract? In this, I remember certain pronouncements by Lord Denning, which I can't readily recall because of my separation from the profession, as I said, for the last 5 years. But I remember one case of the Supreme Court, Brojanath Ganguly versus CIWTC, in which this was taken cognizance of by the Supreme Court. So the difference in bargaining power and therefore the implications of that in shifting liability is still undecided. I would they say that the jury is still out on that. So beyond that, I am not in a position to comment on that, but this is an area of law which the judiciary will require to go into in very great depth, because the law in England is something and the law in India is not quite settled on that. This is the situation in a nutshell as I perceive it.
Thank you, sir, for
Thank
your
you.
views. Shamrat, let's invite Mr. Jayantu Mitra now.
Yes, sir. Sir, my first question to you would be, we know in this pandemic situations, the courts are taking on their only urgent matters virtually. And in your vast experience of more than 50 years, how do you see courts adapting to this new situation? And what should be the legal framework in our coming days?
Good afternoon, everybody. Before I answer the question put by Shamrat, I would like to make a just preliminary observation, which will be the basis for my answering the questions which have been put by you. You see, we are all mortally scared of the pandemic which has hit the country and the world. And our joint effort is somehow to eliminate this. However, in my view, this pandemic has, from one point of view, has one good effect. It has unified the entire mankind under one umbrella to fight one common enemy. In the process, it has united all sectors of the economy in a country with a view not only to confront and fight the disaster, but with the common objective to ameliorate the desperate conditions of the suffering countrymen who have all been exposed to the deleterious effect of it. Now, this is the platform, this is the plank on the basis of which I am going to develop my submissions. The legislators, the teachers, the politicians, government officers, social workers, medical people, and even common men are working in their respective fields to ensure welfare of the people. I feel that the judges and the lawyers also are not immune, or rather are not staying away from such joint endeavor. Now, I feel that the final cause of law is the welfare of the society. As a famous jurist once said, the rule that misses its aim cannot permanently justify its existence. This aim of social welfare must be the predominant factor in shaping the judicial procedure. That is my view. And therefore, must ultimately guide the conduct and activities of the judges, the lawyers, and the advocates. The judges who administer justice, and the lawyers and advocates who assist the judges in the justice delivery system. I am not for a moment saying that in the administration of justice, the judges will be required to formulate their own points of view without thinking as to what the precedents had been, as to what the history of the law had been. I am not for a moment saying that they should ignore the existing law at their pleasure in favor of any other rules, which they may hold expedient or wise. As was said by great jurist Benjamin Cardozo, and quote, I'm quoting this, when they are called upon to say how far the existing rules are to be extended or restricted, they must let the welfare of society to fix the path, its direction, and its distance. These are very important words he has uttered. And I personally feel that this should be the guideline. These should be the guiding factors in the affairs of men. I am repeating again. When they are called upon to say how far the existing rules are to be extended or restricted, they must let the welfare of society fix the path, its direction, and its distance. Here, in connection with this, I join in unison with has fallen from Mr. Justice Orijit Banerjee. The directive principles should be our guiding path. Directive principles are the principles which perhaps will entitle the judges and the advocates to say that these are the ingredients, these are the points on the basis of which the welfare of society can be advanced. I feel that the above message, the above is my own message for today on the subject of discussion. That is my opinion. My opinion is that should be the strategy or to the challenges which have confronted the present legal framework in India. We are talking, our subject matter of today's discussion, the strategies and challenges. Now, I say that the strategy should be to challenge which have confronted the present legal framework in India. Now, apropos your question, with regard to, you say, as to whether only urgent matters should be taken virtually. I say no. Who is going to decide which are urgent matters? To me, my client's matter is the most urgent matter. To somebody else, his client matter is the most urgent matter. I do not want to leave it to the learned judges to decide as to which is urgent and which is not urgent. With due respect to Justice Banerjee, who is present here, I say and I repeat that the urgency of a matter should not be at the discretion of the judges. All matters should be taken up. If you say that the virtual system should be the system by which the matters in court should be decided, then in my view, all matters are urgent. Take them up serially. For example, a matter which was initiated in the month of February, which had urgency at that point of time, I should think it is more urgent today in the month of May. So why should a matter which has been filed in the month of April should have precedence in the matter of urgency to my matter which has been filed in the month of February? So my submission with regard to this, that the court should not, in this virtual hearing system, only take up urgent matters. Take them up serially. All the judges should sit. All the advocates should be ready to assist them. All the matters should be taken up serially, exactly in the way it is to be taken up in actual courts. Why should the same system not be followed? I am told in this connection that in Madras, the Madras High Court is having the normal list published every day. And every day, each matter is being called up on the basis of the list serially. So I don't see any reason why the same system should not be followed in Calcutta or anywhere else.
Shamrat, I would like to invite Dushyant Dubey sir on his views on this as Supreme Court Bar's president. Dubey sir, you are there?
Yeah. Good afternoon, everybody. I am fortunate that I am in the august company of Honorable Governor, Mr. Roy, Justice Banerjee, and one of the most respected names in the legal world in the country, Mr. Jayanta Mitra. Thank you very much for these opportunities, Saurabh and Samrat. This is a very sensitive subject and it needs an extremely sensitive approach. Your subject is very important: legal framework, challenges and strategies in the wake of the pandemic. Let me put it this way: the challenges are insurmountable and the strategies are singularly absent. Judiciary has done precious little to really face the challenge across the country, including in the Supreme Court. If I may be permitted to say so, has invoked force majeure clause to shut down the courts virtually. And the kind of hearings which are taking place in every high court, including the Madras High Court, and particularly in Supreme Court, I would say are dismal, pathetically low, and completely defeat the very purpose of administration of justice. Justice is being denied to hundreds of millions of Indians every day. Forget welfare state. We are talking about constitution and the fundamental rights. People's rights, fundamental rights and legal rights, constitutional rights are being trampled upon on virtually every day. And the judges are just looking the other way. And, you know, as Mr. Mitra rightly points out, the listing of matters is, I mean, I would say, I mean, with greatest respects, especially in Supreme Court, is deeply disturbing and very unfortunate. I mean, I know of cases where various corpus petitions are deliberately not being listed. And it is something which is really, I mean, we are all, you know, extremely religious people. We are proud, of our religion. I mean, for judges to take up matters, whether a Rath Yatra should take place or not, and not hear matters of people whose, you know, right to liberty is being deprived of, to my mind, does not speak well for my judiciary, which I respect immensely. So I think, and there are large number of such cases. I don't want to go into the details of that. Question is judiciary prepared to face this challenge? The answer is, it was not prepared, it is not prepared, and it will not be prepared at any point of time. virtual hearings are farcical, and they cannot even supplement, as Justice Banerjee very passionately puts, to physical hearings. Because you need, a system which will demand thousands and thousands of crores of rupees to be invested for making our legal system virtual, hearing friendly, or to digitize the judicial system. I don't think the government has those funds. And I don't think even if government had the funds, government would be interested in giving those funds to the judiciary, because the executive generally is not very, very happy about strengthening the judiciary, as my experience shows over 42 years. We will have to therefore, change the entire approach in the matter if you have to really start. England spent almost 1.5 billion pounds on digitization in last about 4 years, 5 years, and it has not even been able to achieve in 50% of the courts in United Kingdom. And believe you me, the entire legal system is perhaps in United Kingdom is not even as big as it would be in state of West Bengal. So I think, what we are talking about is a very, very difficult task, and we really need, we are a poor nation. Let's face that. We need resources, and our resources today cannot be, diverted towards computerization of the legal system. We have many other problems, including feeding people, creating jobs for them. There are all kinds of myriad problems in this country, and therefore we will have to look at it very differently. To my mind, presently, the solution can be physical courts as early as possible in the strictest possible manner, where if you are going to have direct televised hearings of all courts, you can straight away dispense with appearances of the clients from the courts. One, you can then dispense with the attendance of, large number of junior clerks coming into courtrooms. You can restrict the attendance in every hearing to the lawyers of the two sides and maybe the briefing counsels. So that's the way we'll have to start doing it, and we'll have to do it. Coupled with that, judges and bar particularly will have to be much more responsible. The bar must agree to confine their submissions to specified time limits that may be set by the judges. Because, this kind of a situation calls for a very, different kind of an approach. You have to think out of box. You can't have the liberty or the leisure that we have had so far to argue ad nauseum, even when judges are completely tired of our, our hearings, arguments, and go on repeating and repeating and repeating. We must be extremely precise, as they do in the Western, courts, especially in the United States and the Supreme Court of United Kingdom now. So the bar will have to be much more responsible, and I would like judges to be much more stricter with us, and we should really be happy. That's one aspect of the matter. The other aspect, which the governors have very rightly pointed out, the National Disaster Act is a classic document of federalism in action. It provides for a national plan by the central government, it provides for state plan by the state government, and it provides for district plan by the district authorities. But the state and the district plan have to be in tune with the national plan. So this is a situation, unfortunately, for whatever reason, Government of India has not prepared a national plan to fight COVID-19. More than 4,500 circulars, orders, and guidelines have been issued, but there is no one consolidated plan. And secondly, what Justice Banerjee rightly pointed out, to which governors have also echoed, and Mr. Jayanto Mitra very passionately put, welfare state. Two provisions of the National Disaster Management Act expressly provide or contain principles of directive, principles of under the Constitution. Article 41, for example. One, when you prepare a national plan, amongst the preventive measures, you must also take the mitigating measures. That's one under Section 11. Section 12(3) expressly provides, and this is very important, it says that when guidelines are prepared for minimum standards of relief, one relief will be ex gratia assistance on account of loss of life, as also on assistance on account of damage to houses for restoration of means of livelihood. Now, therefore, if the national plan was there, the national plan could have provided what you are very rightly pointing out, hundreds of millions of workers in unorganized sector in a realistic way. If you have an unrealistic legislation, it's not going to work. But a plan would have worked with specific guidelines, because then, as Western countries have done today, that entire assistance is not coming from employers. 50% is given by the employer, 50% is being given by the state in entire European Union. Now, that's the kind of an approach which could have really mitigated the hardship of the people. So really speaking, what has happened, unfortunately, is that there is no national plan available today to fight COVID-19. Government is only relying on a plan prepared in 2019, which is the normal annual plan, which deals with this kind of a situation in one paragraph. I have read it very thoroughly. And it's therefore time has come. So I think, really speaking, when it comes to legal framework, we need to really restart the physical hearing as best as we can. The bar and the bench will have to sit together, find solution in which our lives are protected. I'm not for a moment suggesting that it should be done at the cost of anybody's health, but it certainly can't be at the cost of justice. Do not forget, we are service providers.
Mr.
Sir,
Ghosh,
thank you.
Mr. Ghosh,
Yes.
Mr. Dave, you're absolutely right that the bar and the bench will have to sit together and find out the ways and means of resuming physical court. That's dialogue is going on between the judges and the learned lawyers in Calcutta. I can tell you that. I have personal knowledge. Another problem is there is no agreement amongst the learned lawyers. That's another problem we are facing. A section of the learned lawyers say, enough is enough. We want to resume physical court. We don't want to die of hunger. Let us die of COVID, if necessary. The majority seems to be saying, no, don't be ridiculous. It's dangerous. It's spiking up every day. We don't want to come for physical court. Now, this is a problem that we are facing here. Mr. Mitro will probably...
You are absolutely right that there is a division of opinion between the two sets of lawyers. But please consider from this point of view. There are a set of lawyers who are coming from the districts. There is a handful number of people who are coming from Calcutta. Well, let us proceed on the basis 50-50. Those who are coming from districts, they have to expose themselves in public transport, in standing in the queue for getting into the bus or into the steamer to cross the Ganges. Now, they are exposing themselves to this. That is why they are apprehensive that by coming to court and doing their matter in court, in physical court, they will be exposing themselves. But I agree with Dushyant. He is absolutely right that virtual court can never be a substitute for physical court. Can never be a substitute. We will have to think in terms of opening up the physical court. If we cannot do it now, we'll have to wait until the situation improves. But the point remains, the fact remains that without the physical court starting, it is not possible to deliver justice to the people for two reasons. Number one, you cannot be selective in the matter of which is urgent and which is not urgent. I strongly object to that. The judges selecting which is the urgent matter and which is not. Secondly, and this is very important, by going into virtual court, you are excluding the public from public hearing. The courts are public places. You know the provision is there in the Constitution of India, Article 145. You know there is a provision in the Civil Procedure Code, Section 153 and 153B. And there is also Criminal Procedure Code, Section 327. These are public places where the public will have access. My clients, when there had been virtual courts, had been complaining to me that, sir, we could not hear what was happening. what submissions were made, and what answers were given, and what observations were made by the court. Now, this particular complaint will continue to remain so long as you don't have live streaming of the proceedings in court, and so long as the courts are not well equipped with this system of live streaming of court proceedings. I say that you are not delivering justice. Delivery of justice is big. After all, remember one thing, that access to justice is one of the fundamental rights under Article 21 of the Constitution of India. So why should the people in the streets not be given this opportunity of hearing their own case? It is like a court of law is a temple of justice. You have access in the temple. Similarly, you have access in the courts of law. And this access should not be curtailed by virtual hearing.
Mr. Mitro, please take it from me. We are making all efforts in Calcutta High Court, all efforts. We are having a discussion almost on a daily basis on how to resume physical court at the earliest. We are all aware, and you might recall, I started by saying virtual courts cannot be a substitute for physical courts.
Yes, absolutely.
For several reasons.
Yes.
Therefore, we are all conscious.
Strong practical views.
Yes. And what Mr. Dave says, I appreciate that the courts were not prepared, are not prepared, may not be prepared in future to have an entirely virtual system because also of the costs involved, enormous costs involved. We appreciate. But conceptually, I had expressed my opinion that virtual court conceptually may supplement physical court.
You know, one of the problems which the courts have, for example, in Supreme Court, is that the judges have selected a technology which is totally out of date.
Absolutely,
video
absolutely.
By NIC, we have been, representing the bar. I can tell you, dialogue with the best service providers in the world, and they are willing to give a platform which will enable all 16 courts to work with all lawyers attending virtually. And we can, as a bar association, provide various kiosks where lawyers who don't have access can be provided, even in remote centers like Gurgaon or Noida or Faridabad, from where lawyers come, and we can provide some access to them. All this can be easily done, and it is not a substantial cost. The cost that I have been given to understand is not more than 10 to 15 crores of rupees. And yet, I can tell you that the judges are not willing to, they want to follow the regular tender process, Government of India's approval, this, that. Now that thing cannot work, unfortunately. I feel that, Justice Banerjee approaches what you rightly pointed out, that there are two sections. Even in my bar, there are two sections. But judges will have to take the final call and insist. And those lawyers who are unable to attend from districts or from satellite townships like Gurgaon, Noida, and other places, they will have to make alternative arrangements and request their friends to appear. Because ultimately, for us, client is most important, the litigant. The most important stakeholder in administration of justice is litigant. He needs to be heard. He wants to be heard. We can't find excuses to say, I am not able to reach, I don't have a computer, I don't have an internet. Of course you don't have. But how is he bothered about it? He needs justice. So we have to think something out of the box, and perhaps Governor Saab can guide us as an elder statesman as to how we should go about it.
No, actually, I was meaning to make one or two submissions which have got nothing to do with the subject which is under discussion. Actually, I can't comment on what Mr. Dave has been saying, and the other has been the matter that has been under argument among the three of you, because I've never, I've never practiced in court. I have attended court as a litigant, particularly when I was working in the metro railway project of Kolkata. I used to attend the Calcutta High Court on a regular basis on a plethora of subjects, litigations concerning land acquisition, arbitration, contractual disputes, bank guarantee disputes, and the like. So, but that doesn't enable me to comment on this thing. But I had a few other submissions which have got nothing to do with the subject, which have suggested themselves to me in the course of the very learned discussions that I have heard from the three panelists here. So may I place them before you for your kind consideration. One point that Mr. Dushwant Dave had mentioned is that the judiciary has been adjudicating on things like Rath Yatra, and is the judiciary prepared to jettison these things and take up really important things? I think that is what he was trying to say. Now the point is, this is not the judiciary's fault. This is the fault of the political leadership, because lately a tendency has developed that the political leadership, I have been on the fringes of that thing, so I have some authority to speak on that. The political leadership has lost the courage to take what we call bold decisions. And as a result of that, there is always this temptation to push everything onto the shoulders of the judiciary, so that let the judiciary decide what can we do. We have seen a demonstration of that in the very recent past in respect of the Ram Janambhoomi case. Why couldn't we decide on the Ram Janambhoomi case? But we couldn't. It is not for the judiciary to decide such things, but we pushed it on them. Then before that, there was another thing that was regarding the plying of diesel vehicles in the city of Delhi. Now, the government could very well have taken a decision that diesel vehicles should not be allowed to ply in the city of Delhi in view of the extreme air pollution that exists there, particularly in the season of winter. But the government did not. They pushed it on the judiciary, and the judiciary also hemmed and hawed about it until Justice Kuldeep Singh, if I remember correctly, Justice Kuldeep Singh took a call on it and forced it. And I heard a remark by someone that even the judiciary was scared to take a decision, but it took a Sardar to do it. And he did it. And we are grateful that he did it. So that is one thing that has to be impressed upon the executive. It has to be impressed upon the political leadership, that don't push everything on the judiciary. Whether Rath Yatra is to take place or not, you decide. Then if somebody is aggrieved with that decision, then he can go to the judiciary and ask for redress. But willy-nilly, you try to push it onto the judiciary so that you are freed of the responsibility of taking a decision. I don't think that is the correct approach to do it. Now, I generally agree on what Mr. Dave has said on the inescapability of physical courts. Inescapability of physical courts, you can't do away with them. Someone, I think Arijit Banerjee or Mr. Jayanta Mitra had remarked on the necessity to observe the demeanor of a witness while he is under examination, which is not possible in a virtual court. Perhaps with the development of technology, that will be made possible. But even then, that will not dispense with the need to have physical court. Now, I come to a subject quite out of syllabus over here, nothing to do with COVID or anything, which has agitated my mind for some time, because I have been a lawyer, I have been a client, and I have been, as an arbitrator, I have been a bit of a judge also. See, in this country, for anything that you need to be done, say for instance, you need a bridge to be constructed, or you need some 1,000 bales of jute to be shipped to UK. Now, if you take such a proposal to someone like that, then the first questions you would be asked is, number one, how long will it take and how much will it cost? Now, these two are questions that can never be asked to a lawyer. Now, I very humbly, very respectfully submit that they ought to be asked, and the lawyers ought to be able to answer them, because they are fair questions. And we, knowing the judicial delays that take place in this country, justice delayed and justice delayed is justice denied, and then the opposite, justice hurried is justice buried. We have all gone through that entire gamut of sayings and counter sayings. But it ought to be somehow ingrained in the legal and judicial system that a litigant, when going into a litigation, ought to know how much it is going to cost and how long it is going to take. Otherwise, case will be decided, and then finally, when we look at the substance with the transcript of the case after it has been decided, we'll see by LR, that is legal representative. The litigant has died, perhaps his next generation has also died, and it is being done by it is handled by his grandchildren, by LR. That is not a desirable state of affairs. So I very humbly submit that this can be done. And one way in which I submit again that this can be done is by putting a cap on the length of oral submissions. Mr. Dushyant Dave had referred to this thing. This is, as far as I know, this is in vogue in American courts, that there is a cap on the length of oral submission that you make. You can make the rest of a huge submission, but the rest of the submission you make in writing. Now, whether that can be introduced in Indian courts or not is a thing for the legal community to consider, but I very humbly submit that it ought to be. In the interest of legality, in the interest of justice, it ought to be done, and the litigant ought to have the right to know how long it is going to take and how much it is going to cost.
May I interject and put a question to the Honorable Governor, His Excellency the Governor?
Please.
May I?
Please.
Yes, go ahead, sir.
His Excellency the Governor,
Yeah.
okay, as Mr. Tathagata Rai has a long experience in arbitration. Now tell me, during your tenure as an arbitrator and during all these years, have you been able to either restrict the lawyer with regard to his submissions and the length of submissions that he has been making, or could you foresee as to how many sittings a particular arbitration will take? Could you? This is my very respectful question to you.
Sir, the answer is in the negative. Obviously, you know and I know that I have not been able to. But in order that I would be able to, I am submitting that this ought to be made the rule in courts, and if it is made the rule in courts, it can very well be made the rule in arbitrations. I will just take 1 minute or 2 minutes to describe a very sad case of an arbitration in which I attended as a counsel. The case went on for 10 years. The sole arbitrator was a retired justice of the Supreme Court. And
did he survive?
I don't think he is. I don't think he is alive yet, but he survived the arbitration. He survived the arbitration after 10 years of submission, witness action and everything. Finally, he said, I am totally confused. I can't hear, so I can't pronounce any award. That was it. Imagine the state of the clients. I can,
I have a question.
In private conversation, I can tell you the name of the judge. You know him very well.
No, please don't.
Huh?
Please don't.
Yeah.
No, but not here, certainly not here.
Yeah, I have an interesting question for Mr. Dave. I know Mr. Dave has issued many letters to the Chief Justice and the Collegium. Sir, do you think that Supreme Court should be more proactive in taking up cases suo moto that they did in the migrant labor's case?
Undoubtedly, there is no doubt that judges have to be proactive in a situation like this, because this is the most extraordinary challenge that humanity is facing. And let us understand one thing, that out of 130 crore people, there must be, at least to my mind, and I'm making a, I'm making a layman's guess, that to my mind, almost a 90 crore people would be needing some kind of help from the state or from somebody else. And, if you can't, if the state is unable to provide that kind of a help, then I think we have really failed to achieve the basic constitutional philosophy of, social justice that we are supposed to do in a welfare state. So I think judges have to be far more proactive. They should have been proactive. They should have really tested the government on many issues. I don't want to go into what issues they could have gone into, but they certainly should have gone into many, many issues and confronted the government as to why the government has either been guilty of inactions, or how governments are guilty of actions in combating COVID-19.
Sir, do you think that the bars under lockdown, what has been enforced, are somewhere hurting the personal liberties of the citizen and is somewhere against the Article 21 of Constitution?
Well, 21 is now an extremely wide facet, and right to livelihood, for example, is one of them. Right to dignified life is another. So there are many facets of right to life under Article 21, which the Supreme Court has very beautifully now expounded over last 70 years plus. And those rights, there is no doubt that we have not been able to ensure that those rights are, guaranteed to the citizens, even during normal times, and far more during a challenge like COVID-19. So there is no doubt that the rights of citizens are seriously affected. And take, for example, various state governments taking the stand. Suddenly, when migrant worker is going, state governments are saying that you will not be able to enter the state to which you belong. Now, does the state government know that there is something called Article 19, which entitles every citizen to travel anywhere? I mean, and you don't make any kind of an arrangement on the borders, you spray them with insecticides. I mean, what kind of, are we treating people like animals? This is absolutely unacceptable. I mean, I can give millions and millions of examples like this, which are happening on a daily basis. Judiciary is, unfortunately, the problem. Why is it that the judiciary has to step in? Because there is a serious failure on the part of the executive in more than one way. And that is where judiciary has to step in, because that's their constitutional duty. In a separate theory of separation of power, the judiciary's duty is to ensure that the constitution is implemented by the executive in letter and spirit. No government can function outside the constitution. And the moment you find in any which way that constitution is not being followed, then you have to strike. I mean, and that's why, you have to say hats off to judges like Bhagwati and all, who gave us this beautiful, weapon called public interest litigation. And that is really the answer in a poor country like India. Because, how many people can afford lawyers? We are all inaccessible to, I think, a vast majority of the population. Whatever may be the reason. I mean, even if I were to do, which I do, about 75 to 100 matters free in a year. But even then, how many people can approach me? So, I mean, there are limitations. And that is where a judge has to really realize that you have to, actively get involved. You have to look at the newspapers, find issues which are affecting, the very survival of people, and strike at the government. I'm not saying that you must have a confrontation with the executive, but you must have I would say, a kind of a healthy struggle with the government constantly between judiciary and the executive, so that you can keep them under check. You can remind them of their duties. You can remind them of their obligations. And that is what is singularly missing, especially during COVID-19.
So I have a question for Mr. Mitra.
Just 1 second, please. With all due respect, the point that I was trying to make, that usurping of the role of the executive, or thrusting the role of the executive on the judiciary, and answering those two questions, how much will it cost and how long will it take? Would the three very learned panelists kindly throw some light on it, whether they're practicable or not, whether they're advisable or not, anything?
I let me respond to that, Governor Saab. I think it's a complete misnomer to say that the judiciary is usurping the power of the executive. That's not the way to understand constitution, with greatest respect, sir. The judiciary has a specified duty. Namely, under Article 32, Supreme Court has an express obligation, and Ambedkar said that that is the most important article of the Constitution. Supreme Court has an obligation to ensure that the fundamental rights of the citizens are enforced in letter and spirit. Likewise, high courts have even wider power. Not just the fundamental rights, but the constitutional rights and the legal rights are properly enforced. And that is why Ambedkar said, in fact, when Pandit Nehru gave him the first draft on the opening day, if you would read the opening speech, he was deeply critical of the draft which was given to him. And he said, what kind of draft is this of the Constitution, which does not provide for remedy? It only provides about rights. He says, what is this discussion about rights if the remedies are not provided? And that is where, the drafting committee came out with 32 and 226. So I would respectfully urge that this is a very healthy working of a constitution. And nothing wrong about it. Look at United States Supreme Court. I mean, in any and every way, it's not that they don't interfere. They do. For example, only yesterday they said that President Trump must disclose his income tax to the public prosecutors. Now, somebody might say what business Supreme Court had. But the Supreme Court of United States felt that, yes, it is absolutely necessary for a man sitting at the top of our democracy to be open about everything. And he can't hide behind some kind of, defenses. Likewise, yesterday they have given a judgment and said that vast tracts of lands, and this is very important for us to understand because, the Adivasi rights are seriously being compromised in this country. The United States Supreme Court said yesterday that vast tracts of lands which belonged to Native Americans, their criminal offenses committed on those lands are to be looked at differently, and state laws will not apply to them. Now, that's the kind of approach. So I am not for a moment suggesting that judiciary should take over. No, judiciary's role is supervision. And where it finds failure, it must act. That's how I look at it.
I wholly agree with what Dushyant has said. Courts have to step in where the executive had been failing. There has to be checks and balances. The executives can't be right all the time. Wherever there is a failure, there has to be some kind of a stopcock. And I say that the judiciary has to step in as a stopcock for the purpose of controlling either excesses or the failures of the executive.
So let's say one more. Just a sec, Justice Banerjee. Yes. For example, two of the Supreme Court's decisions, which have been criticized even by top counsels who appeared and lost, 2G and Colgate cases, they were the ones which really struck at the very functioning of the crony capitalism in the country. And judges found that what had happened in distribution of 2G licenses or in distribution of coal mines was done with improper motives. Now, at that point of time, the government in power today, Bharatiya Janata Party, was extremely nostalgic about the Supreme Court, saying that the Supreme Court has done a greatest service to the country. Today, when Supreme Court and judges start questioning the government simply says, oh, the judges are interfering with the functioning of the executive. I don't understand this.
Nonsense.
You can't have it this
Absolute
way.
Nonsense.
So it is to be, and sir, one thing, for example, the standards and morality in public life has eroded to such an extent that it is impossible to even conceive. In my 42 years, I am seeing in court what governments are doing is absolutely a matter of shame. Matter of shame. In no democracy, this kind of behavior will be tolerated of the executive. So why is it that the judiciary therefore has to step in? Unfortunately, we don't have a vibrant democracy, judiciary. Let me tell you, judiciary doesn't strike at them. Today, judiciary is approving virtually everything that the government is doing, and which is not good for future generations. What kind of a nation we are going to give it to future generations of India is something which is troubling me from inside. We need a vibrant democracy where everybody has the highest standards in public life. Judges, executives, parliamentarians, everybody, and civil society also. We all need to do that, and sir, you know it better than I do, having been in public life, what our public life has reduced itself.
And my last question, says, how long it is going to take and how much will it cost?
Mr. Roy, I personally feel that those two questions cannot be answered unless, at least by legislation or by some statutory rule, the time period for which a party can speak in an arbitration or a court proceeding can be limited or restricted. I can tell you it is very difficult for a judge hearing a matter to tell a learned counsel, I've heard you enough, please sit down. Immediately, the judge will attract the wrath of not only that learned counsel, but of others. And people will go out of the court feeling unhappy. If there is a statutory rule or a legislation by amendment of the CPC or otherwise, then the blame won't be on the judge. Well, it's the parliament which has limited the period. Well, under those circumstances, perhaps it may be possible to answer those two questions. How long and how much will it cost?
And about the second one has got to do with Champati law. What would you say on that?
Yes,
how much it is going to cost?
Mr. Mitro?
I am not experienced in Champati law. I'm sorry. I don't know how much it will cost.
I have a small question for Mr. Mitra. It's a legal question, and these questions are coming from different people a lot nowadays. Suddenly, this force majeure is a keyword which has come in the legal circuit, and so invoking force majeure clause, does it mean that from that day the other clauses of the contract goes into suspension?
No, certainly not. Certainly not. You see, we have to understand the implications of a force majeure clause. You see, many of the contracts, I should say most of the contracts nowadays contains a force majeure clause. If there is a force majeure clause, then the parties are bound by it. In other words, if the contracting party, if there is actually a force majeure situation has arisen, then the affected party, let me put it this way, affected party would be entitled to give notice to the other party saying that, look, a force majeure situation has arisen, a situation has arisen which is not within my control, a situation has arisen which I was not contemplated at the point of time when the contract was entered into, a situation has arisen by reason of which I am not being able to perform my obligations under the contract. Now, once that comes in terms of the contract, the other party has got in the contract clause itself the obligation. He can either say, in that view of the matter, yes, I agree with what you are saying. I am keeping the obligation that you are to carry out in suspension for the time being. Or I say that I am for the time being not insisting upon your obligation for being performed. Let me give you an example. A road building contract. Road to be constructed from Calcutta to, say, Burdwan. Halfway through, the COVID situation had arisen, or any other situation had arisen. As a result of which, the workforce of the contractor had left work, gone back home. The source of finance that the contractor had been having for the purpose of implementation of the contract, that had dried up for the time being. Now the contractor writes to the employer that, look, a force majeure situation has arisen. Please say what I am going to do. I am giving you this notice. Please allow me to suspend the work. The employer will say that if you suspend work, I will suspend payment. Now then it will come, the parties will have to sit together, will have to find out what is contained in the contract, implement the contract and carry out the work in the way it has to be done. Either suspend it or keep it in abeyance or whatever. But mind you, this is strictly in terms of the force majeure clause. So if there is a force majeure clause, it will have to be carried out in those terms. Now, when a contracting party, the affected party, gives notice, he is putting on notice the employer saying that a situation has arisen which can be said to be a force majeure situation. In a situation like that, it is the employer who will have to take a decision in terms of the contract as to what is to be done. Now, automatically, unless there is a specific provision to that effect, there cannot be an automatic suspension only because I have given notice of a force majeure situation.
This is so contracts.
Yes.
When I issue a notice of force majeure in an infrastructure contract, and the employer takes a decision to invoke the bank guarantee for due to non-performance, should the courts be lenient at this point of? You know, the bank guarantee invocation laws are very strict. Special liquidity fraud has to be looked into.
Here, in a situation like this, for example, today's situation, I would think the courts will have to be proactive and the courts will have to be innovative. We all know that the bank guarantee clauses are very strict clauses, which the beneficiary is entitled to invoke whenever there is a breach or whenever there is a perceived breach. Let me put it this way, not breach, perceived breach. And once he invokes it, then the bank, without demur, without protest, will have to pay up the money. This is the law. And this particular law in England, in America, in India, in Australia, the same law all over. This law had been prevalent, and we have got umpteen number of cases in which the courts have said, no, sorry, no injunction can be granted. Now today, if a situation like this arises, according to me, the courts will have to be innovative for the purpose of granting relief to the person against whom the bank guarantee is sought to be invoked. Why? The court will have to say, of course, fraud situation is not arising here. Why can't the court rely upon the principle of special equity? That is a way out. Definitely the court can say that a situation has arisen where I shall invoke the principle of special equity in a situation like this, and therefore I shall pass an order of injunction restraining the invocation of the bank guarantee. This is where the court has to be proactive, the court has to be innovative. And we have found that, excepting in one case in Bombay, there had been quite a number of decisions in Madras and Delhi where the invocation of the bank guarantee has been restrained on the ground of COVID-19.
I will invite Mr. Dave. Then is COVID-19 situation a special equity situation?
It's very interesting. You have to understand one thing, that force majeure in a situation of COVID will be available to both parties in a contract. So if the contractor is pressing force majeure to say that I am unable to perform, therefore don't encash my bank guarantee, the employer can also say that I have also suffered on account of COVID-19 and I am therefore unable to extend this contract for whatever reasons. I think COVID-19 is a situation where we will have to decide, except those cases where the subject matter disappears, subject matter of the contract, and impossibility is true impossibility in real sense. I think merely talking about force majeure is not going to help. Yes, in all cases, or I would say overwhelming percentage of cases, the parties will have to sit down and extend the time limits. And
may I add something to it?
That's the only way to move forward. Otherwise, one party to say I have suffered and equity in my favor. The other party has also suffered on COVID. So it's going to be very difficult. I mean, look at government today. Any state government is virtually bankrupt on account of COVID-19. Its source of revenue of, taxes is gone. The expenditure on fighting COVID is enormous. How is the government going to give that contractor any money at this point of time?
So enforce bank guarantee and take the money.
No, I'm not saying bank guarantee. That's why I'm saying extend. Mr. Mitra, you didn't hear me. Both sides will have to sit together and extend the contract in most of these cases.
Correct. That is the point. That is exactly what I'm saying.
May I add just one point? I completely agree with
Sir, respectfully, last comment, because we have consumed the time, then we'll go for question answer live.
Fair enough,
Please,
but
sir,
that only proves that the discussion has been very interesting. Right. But I completely agree with what Mr. Dave, but I will draw a very fine distinction between frustration and force majeure clause. Force majeure clauses in contracts usually are there so as to operate the shifting of the liability from one party to another.
No.
Say, for instance, I am a contractor and I'm working on a riverbed, and then I have got my equipment on the riverbed, then a flash flood comes and takes away my equipment, washes away my equipment. I have, in the first instance, I have suffered losses, but should the losses be compensated by my employer? This is a question which would be decided by a proper construction of the force majeure clause. But impossibility, which is laid down in section 56 of the Contract Act, is a different thing altogether. This is because of supervening circumstances that you can do nothing about it. There is a classic case, I forget the name of the case, in which there was a building contract to construct a building in a place called Hyderabad, not our Hyderabad, but the Hyderabad which is in Sindh, in Pakistan. And after the contract was entered into, Hyderabad happened to be in Pakistan. So it was impossible. That is a classic case of supervening circumstances which make the contract impossible. For that, you don't need a force majeure clause. For that, the recital of the circumstances in my submission should be sufficient.
Yes. Shamrat, you can ask the questions now, which has come from the attendees.
We can, yes.
And also announce for the, going live with the public.
So what we can do, we can go live, and then I put in those questions in between whenever this. So that will be better suited, I suppose.
Akshay, put us on live. Shamrat, you can start with the questions on the box.
Okay.
So we have Mr. Gautam Sen online. Mr. Gautam Sen, can you unmute yourself and ask your question live? Mr. Gautam Sen, this is last and final call. Can you please unmute yourself and ask your question live? Samrat sir, there seems to be a technical glitch. Can you please take up questions in the Q&A box?
If he has written the question, you can read it out.
No, he has not written the question, so the questions are somewhat different. So I'll read it out. One question is that there are varied position of lockdowns from state to state. In view of this, whether time bar position will also vary, or there will be a uniform limitation period to be declared by the court. This, I suppose, refers to the limitation of the statutes and etc., which we know that Supreme Court has already granted a blanket order, and which is still in force, I suppose, subject to what the way can clarify that. But he wants to know that what is the position of limitation, as there is a lockdown in different states.
The Supreme Court's order, in fact, was at joint instance of myself and Mr. Tushar Mehta. And we had requested the Honorable Supreme Court we were physically present on 23rd in Supreme Court when we suddenly thought of this and requested judges. And I must say Chief Justice Bobde's bench was extremely receptive. And what they have done is, that they have automatically extended by that order till further orders are passed by the Supreme Court, the period of limitation in respect of every action that anybody has to file before a court or before a tribunal under the central law or under the state law. So every kind of limitation now stands extended by virtue of that.
Yes. Sir, next question is regarding our consumer forums in Kolkata. So, question is, will the pending cases in consumer forum Kolkata, which are pending from long time, can those courts be mitigated through, again, this virtual courts room, we shall mitigate the physical hearing? But again, and the same process will go lengthy as there is no solution to the present pandemic. So that's again, we are on the same thing that whether virtual courts can do the consumer forum hearings or not. But as
The second
Mr.
question
Mitra
is
was,
also similar to that.
No, but let me tell
yes,
you,
but
just a sec. Let
as
me tell
Mr. Mitra was,
NCDRF has found a fantastic solution, and they have digitized every case free of charge. They are giving it to the lawyers of both sides, and the hearings are taking place on virtual basis in a very systematic way. So perhaps they should appeal to NCDRF to extend that to state consumer forums also.
also correct, sir. So
Samrat sir, can we take a live question?
yeah,
Yeah, please carry
go
on.
ahead.
Mr. R.V. Reddy, please ask your question live.
Good afternoon. This question is to President Mr. Dushyant Dave. What about the cases of senior citizens which are supposed to be taken out of turn, but which are still pending for decades in our courts?
Well, they will remain pending for decades to come, unfortunately. I'm sorry to inform you that, Mr. Reddy. The problem is that judges need management techniques. And unless and until the judges, as an institution, the judges sit together with top management experts on how to control their files, unless they sit down with jointly with the bar, it is impossible to address this situation, because for example, the files which are pending in Supreme Court registry are in such pathetic conditions. I can tell you, the registry's staff, I marvel at the unhygienic and unhealthy conditions in which they must be sitting. They are virtually sitting in basements with no ventilation, as air conditioning works, but I mean, it's very unhealthy. The files all over, very little place to even move from one place to another. We need really to have scientific management principles to now govern our judicial system. Unless that happens, and these categories have to be drawn out by the management experts, placed before the judges and the bar, and then we have to move together. I don't know when that will happen. It will require a very serious effort on the part of the judges. I don't know whether they are willing to do it or not.
Thank you, Mr. Dave. Over to you, Samrat sir.
There is one question from Mr. Surendra Singhal, which I would like to read out. What is the remedy for MSMEs who get entangled in litigation after arbitral award is published? If the district court does not dispose the petition under section 13 within statutory 12 months as per the 2015 Act. So, Mr. Sir, you can take this one question. What is the remedy? He is asking what is the remedy once the arbitral award is published, so that the 34 has to be statutory limit of
I think the remedy
by
is
2015 amended.
I think the remedy is, which we regularly do, we approach the higher court in a 227, 226 petition for fixing a time of 2-3 months, 6 months, so that the subordinate court finishes off the matter. I don't think there is any other remedy. I mean, if Mr. Mitra might guide us.
No, I think that is all that we can. This is exactly what we have been doing. If the relief is not being obtained because of the lackadaisical attitude of the lower court, Article 227 is the only remedy by which you can get the direction from your higher court for the purpose of.
That is right. It is the supervisory jurisdiction of the high court.
That is the only way, I think.
Yes.
No, there is another way out. We can petition the Law Commission or the MPs or whoever to take it out of the jurisdiction of the lower courts, because I have one practical experience about it. There was a case in which I was counsel, arbitration, in which there was an award of 330 crores in favor of a Japanese party. And when we took it to the, it was of course challenged. Every award against the government is challenged as a matter of course. And when we took it to the District Court of South 24 Parganas, we could clearly see that the poor judge was out of his depths. He did not know the first thing about it. So he kept on postponing it. Ultimately, my client or the solicitor did not choose to take it under 227 and eventually got some, permit me to say so, cock and bull judgment. And then we went on appeal and then we got the award to be upheld.
This is for my education, Mr. Mitro, Mr. Dave and Mr. Roy. Would it be possible for such an aggrieved party to apply under section 24 of CPC or clause 13 of the letter patent for withdrawal of the setting aside application to the High Court itself, because the district court is unable to dispose of after a long time?
That is available only to Calcutta High Court.
No, section 24 would be available to all the High Courts.
That is right. Letters patent. No, you mentioned letters patent.
Yes.
No.
Yes.
Section 24.
Yes.
CPC.
That is a possibility, isn't it?
Yes, that's the possibility. That's the possibility. You are a judge. Would you entertain the application and pass an order? Then I shall go to you.
I'll give that question a pass.
We have Mr. Gautam Sen again. Mr. Gautam Sen, can you please unmute yourself and ask your question live? This is last and final attempt for you, Mr. Gautam Sen.
Still mute.
Mr. Sen,
over to you, Mr. Samrat.
Mr. Dave was trying to say something. Shall we hear him?
Please, sir.
Please, sir. I said that no court in the country will pass such an order. And we know of the celebrated story of Justice Sabyasachi Mukherjee in Calcutta High Court when Supreme Court directed him to hear a particular matter.
Oh, yes.
Out of turn. He refused to do it. And ultimately, when he came to the Supreme Court, he did not talk to the judge who had passed the directive, in that matter till he retired.
Yes, I remember that.
I didn't know that. Celebrated story between Justice Mukherjee and Justice D.A. Desai.
That's right. Justice D.A. Desai sitting with Mr. A.P. Sen.
Right.
Over to you, Samrat sir, for the questions in the Q&A box that we received
yes,
from
sir.
attendees.
Sir, there is one question again related to VC and reports. It starts with that as a classic adage says justice delayed is justice denied.
Sorry, Shamrat.
So do
you are
think
not audible.
Increasing reliance? Hello?
We can't hear you.
Hello?
We can't hear you.
Can't hear me? Hello?
No.
Yes, carry on.
Carry on, you can hear me now?
Yes.
Yeah, okay. So there is one question which I will start from the beginning, which reads out as the classic adage goes, justice delayed is justice denied, justice hurried is also justice buried. So do you think that increasing reliance in virtual courts will render the justice delivery system harder for common layman to access, which already was saying, especially in the smaller towns where there is not enough digital infrastructure?
I think this question has been answered already.
Yes.
Already been answered.
Yes, this has been in the discussions itself. It has been answered by Mr. Dushan Dave.
I have a question for myself. So in the event of any invocation of this Disaster Management Act and Epidemic Act and issuance of various notification by Ministry of Home Affairs, Government of India in awake of this COVID-19, does this situation, can we say there is a change in law already vis-a-vis the contracts and force majeure and everything? Does it amount to change in law?
it will depend upon the notification. I don't know what notifications you're talking about. Unless we see the notification, I won't be able to answer the question.
No, I don't think. I don't think so. Those notifications don't deal with this situation at all. My battery is running out. Sorry.
Okay, we can wind up here. So thank you, everyone. It was a pleasure having this discussion with you all, and thank you to the attendees and Let's Witness.
Before we
yes, sir.
discuss, I have a grievance, and my grievance I'm expressing to all the other honorable panelists. I noticed one of the moderators drinking something from a mug. I presume it's coffee, but that was not offered to us even virtually.
Virtually can't be offered. I will invite you for everyone for a coffee.
That's correct. Thank you.
Thank you, sir. Thank you. Thank you. Pleasure.
So he is inviting you at a time when you can't travel.
Thank you.
Thank you so much, gentlemen. Saurav sir seeking permission to end the webinar for everybody.